Okay, in this video, I'm going to talk about the infringement analysis, primarily for infringement of registered marks, but we'll recognize the difference, or at least the arguable difference, between the infringement analysis for registered and unregistered marks as well. So, in theory, the standard is the same, which is the likelihood of confusion. But trademark owners can sue under different elements of the Lanham Act for infringement of a registered or an unregistered mark. So the standard for a infringement claim in relation to a registered mark is essentially any form of confusion that it might cause in consumers, whatever that might mean. And the standard for infringement of an unregistered mark is infringement or confusion in relation to affiliation, connection, or association with the mark holder, or the relationship, some other relationship between them. So it's confusion about source or relationship more specifically, as opposed to confusion in the case of registered marks, where at least theoretically the nature of the confusion at issue can be broader and potentially include things that wouldn't satisfy the confusion analysis for an unregistered mark. We'll investigate whether or not there's really a meaningful difference between the two. Nevertheless, one advantage, potential advantage of having a registered as opposed to an unregistered mark, is that the owner of a registered mark can sue under both statutes, whereas the owner of an unregistered mark can only sue under the statute pertaining to unregistered marks. So arguably two bites at the apple then for the owner of a registered mark as opposed to an unregistered mark. Okay, so in doing the infringement analysis, courts have established a set of heuristics or rubrics that they use for evaluating the strength of a plaintiff's infringement claim. And these differ from circuit to circuit, right? They're developed by each circuit. And so you have to look to the specific rubric or the specific test adopted by the relevant circuit in question. That said, they're broadly speaking very similar, right? You want to use the language that's specific to the circuit in question, but the overall purpose is the same. And broadly speaking, I think it's fair to say that the tests in all the different circuits are roughly similar, although there are arguable differences both in terms of the language of the test and potentially in the way that circuits actually apply those tests. So you do want to be sensitive to differences amongst the circuits, but the big picture is pretty much the same. And they tend to look to 8 different factors in thinking about what will be relevant to the plaintiff in an infringement action, specifically in relation to a registered mark, making out a claim for infringement by virtue of showing a likelihood of confusion, looking to the qualities related to the plaintiff's mark, right? How strong is the plaintiff's mark? How related are the plaintiffs and defendants' goods or services, right? So stronger the mark, the more likely the plaintiff can show confusion. The more related the goods or services, the higher the likelihood of confusion. The similarity of the two marks, and the more similar they are, the more likely consumers are to be confused, right? Any evidence that consumers were actually in practice confused by the relationship between the products and marks in question, that would be pretty useful in evaluating whether or not confusion had occurred. The marketing channels used, in other words, how are they selling the relevant products? The degree of care and sophistication of the consumers of the relative products. In other words, are consumers likely to be looking carefully at the products, or are they going to be kind of more in a hurry or not paying that much attention? The intent of the defendant. In other words, did the defendant intend to kind of trade improperly on the plaintiff's goodwill, or were they inadvertently taking a mark that they didn't realize was potentially going to be troublesome or problematic? And then the likelihood that the plaintiffs will expand their product offerings in potentially come into conflict with the defendant, or it come closer in terms of the relatedness or goods or services in the future. Well, let's look at an example, right? So everyone knows the company Kellogg's, the largest manufacturers, probably the largest manufacturer of breakfast cereals, among other food products. And one of their well-known products is Fruit Loops cereal with the mascot Toucan Sam. Very familiar mascot, follow your nose, it always knows, et cetera, et cetera. They've used the mascot for a long time. It's undergone changes over that time. You can see an early mascot on the left, a more contemporary mascot in the center. Toucan Golf is a small novelty company, essentially based in Mansfield, Ohio, and they adopt a logo called Golf Bird, which is an image of a toucan sitting. Well, sometimes they put it on a golf club, sometimes they put it on a paintbrush. Basically, they're in the business of producing a bunch of different kinds of products. In any case, Kellogg is very aggressive about policing its brands, and when they come to realize, by virtue of Toucan Golf's trademark registration filing, that Toucan Golf is looking to register a toucan logo for its company, they file a notice of opposition and ultimately bring an action. Okay. Well, what's the analysis that the court does here? They look to the strength of the plaintiff's mark. They say, yeah, no question, Toucan Sam, that's a strong mark for Fruit Loops cereal. So that's a notch in the plaintiff's favor, but they're not really selling related goods, right? I mean, Kellogg occasionally will sell golf-related products, but they're in the breakfast food business. They're selling to the children. They're not really in the golf market selling products to golfers. That kind of more of a notch in the defendant's column. They look to the relatedness of the marks, right? How similar are they? And they see a lot of differences, right? I mean, really the only related element here is that they're both using the word and word toucan and the image of a toucan. And that's a common word, a real bird. The court doesn't really see a whole lot of similarity between the marks there, beyond something that arguably Kellogg shouldn't be able to claim exclusivity over. Any evidence of confusion? Not anything really substantial that Kellogg's can demonstrate. And ultimately what the court does is rely on these kind of big picture factors, right? It does think the mark is strong, but it just doesn't see that the products being produced by Toucan Golf are similar to Kellogg's products, or that the marks in question are really meaningfully similar, right? It says, look, we can tell the difference between the logos. The logos are very quite easily distinguishable, in the sense that Toucan Sam is highly anthropomorphized, at least in his modern incarnation, at least, and the Toucan Golf logo is not. They're using really different kinds of colors, and realistically, consumers are not going to be confused by the relationship between these two logos. Maybe big picture point being, court's pretty reluctant to allow Kellogg's to claim exclusivity over the use of toucans in relation to any kind of product that anyone happens to want to sell. In other words, Kellogg, you can own the toucan in relation to breakfast cereal, but you can't necessarily own toucans in relation to literally everything. That seems like the court thinks that's a little bit too broad. So, broadly speaking, trademark scholars and in courts as well tend to look at this as like a sliding scale, right? So basically, you look at the competitive proximity of the goods as compared to the degree of similarity between the marks, and the closer the goods are together, the more similar the goods being sold by the plaintiff and the defendant, the less similarity is necessary in order to find infringement. In other words, consumers are going to be more likely to be confused if you're in the same basic business. Likewise, the more similar or the less similar the marks, right? The more the closer the products have to be together in order to find a confusion has taken place. By contrast, the more different the markets, the more similarity you're going to need in order for consumers going to be likely to find that confusion is going to take place, right? So in the case of Kellogg's and Toucan Golf, right, the products aren't very similar. So the marks would have to be really, really similar indeed in order for confusion to be likely. And because the marks are pretty different and the products are pretty different, the reality is that the court is unlikely, the court is inclined to find that consumer confusion is unlikely under the circumstances. Okay, well, let's look then at the Experience Hendrix v. Electric Hendrix case. What happened here? Experience Hendrix is effectively the Jimi Hendrix heirs, right? It's the Hendrix family. And they've adopted and registered a range of different Jimi Hendrix related trademarks, which they use in a range of different product categories. And they've been doing that for a long time. The marks in question have achieved incontestable status because they've had them for a long, they've been registered for a long period of time, and they've applied for and been granted incontestable status. However, key point here, under Washington law, which is the relevant law in this particular case, there is no postmortem right of publicity, right? So the Hendrix family can't rely on right of publicity claims to claim exclusivity over the name and likeness of Jimi Hendrix. They have to rely on trademark claims to marks relating to the registered marks that they own relating to the likeness and name of Jimi Hendrix. Okay, well, Electric Hendrix comes in, sort of a hanger-on of the Hendrix crowd, and they start marketing the Jimi Hendrix Electric Vodka, and Experience Hendrix brings an action against them. And the court engages in the same kind of analysis, really walking through all the factors in this case. And it points to this, the strength of the Hendrix mark, right? Very, very strong. Everyone's familiar with Jimi Hendrix and what the Hendrix name and logo means in terms of associating it with a particular mark. Relatedness of goods, essentially the court says, well, their Experience Hendrix licenses just about everything. And, Jimi Hendrix Electric is got some crossover products. Anything promotional they might do could conceivably be related to Jimi Hendrix, even though Experience Hendrix has explicitly said that they are never going to get into the alcohol business in relation to the marks in question. The court doesn't seem to think that matters, right? The fact that Experience Hendrix is explicitly declining to exercise the Hendrix mark in that product category doesn't care, right? It seems to think that, well, there are enough other categories that it could encompass the alcohol category by extension as well. It points to the similarity of the marks in the sense that they both use the Hendrix name and logos. So as a consequence, the marks are indeed quite similar. And as a consequence, consumers are confused in the sense that they assume that products with both the Experience Hendrix and the Jimi Hendrix Electric logo are associated with Jimi Hendrix in some way. Does that mean the Jimi Hendrix estate? What are they associating it with? Is kind of an open question. And they point to the other factors as well, and could pretty much across the board see no reason to think that there isn't a likelihood of consumer confusion under the circumstances. Query, however, exactly what kind of information is being communicated by consumers to consumers by the mark in question, right? Is it information about, is the Experience Hendrix mark communicating information about the source of the products in question, or is the Experience Hendrix mark conveying information to consumers about the kind of endorsement of the Hendrix estate? Are those the same thing? Are those different things? How should we think about them in relation to each other, right? Is the mark, being actually used as a mark in these circumstances, or are they just trying to kind of claim the right to Jimi Hendrix image and name and likeness? And if so, right, is that what trademark law is really for? Or is that really a right of publicity claim in trademark guise? And if that's what's taking place, is that appropriate? Is that the kind of thing that trademark law is supposed to do in the first place?